She said the bridge on my property was a liability. She said the HOA had the authority to remove it, so I let her tear it down. What she didn't know, what she never bothered to check, was that it didn't belong to me. It belonged to the county, and the county does not like people destroying its infrastructure. I moved into Cedar Ridge for the quiet. I'm a civil engineer by trade, transport infrastructure mostly. After 15 years of highway projects and municipal contracts, I wanted trees, running water, and a place where no one cared what I did for a living. The property backed onto a shallow drainage creek. Nothing dramatic. Seasonal flow, concrete culvert upstream, a county-maintained easement cutting across the rear 10 feet of my lot. That detail mattered later. There was a small pedestrian bridge spanning the creek, pressure-treated timber decking, steel stringers, functional, unremarkable. It connected my backyard to a strip of county greenbelt that ran parallel to the neighborhood. The previous owner had told me county put it in after the flood control upgrades. I confirmed that before closing. Easement documents, maintenance map. It wasn't decorative. It was part of the stormwater access corridor. It just happened to sit directly behind my fence. I'd been there 3 weeks when she introduced herself. "Melissa Harding," she said, extending a manicured hand, "HOA president." She didn't smile. Cedar Ridge Homeowners Association had a reputation for being detail-oriented. That's how the realtor phrased it. Melissa preferred proactive. Her first visit was framed as welcome protocol. She walked the perimeter of my yard without asking, paused at the bridge, took a photo. "That structure," she said, "is not compliant with community aesthetics." "It's county infrastructure," I replied calmly, "part of the drainage easement." She tilted her head. "It's on your lot. It's inside an easement." She didn't acknowledge the distinction. Over the next month, the visits became routine. She cited safety concerns. She cited liability exposure. She cited community visual standards. Each time I responded the same way. Permit copies, easement diagrams, county maintenance records. I even printed the relevant section of the recorded plat map and highlighted the access corridor. Melissa never directly accused me of wrongdoing. She implied it. "You understand," she would say, voice low, "that if someone gets hurt, the association may be forced to act." Act how? I wondered. I installed 2 exterior cameras after the 3rd unannounced visit, not because I felt threatened, because I felt documented harassment building towards something tangible. I work in infrastructure. I've seen this before. People who assume authority is the same thing as jurisdiction. One afternoon, I came home to find a fluorescent orange tag zip-tied to the bridge railing. Unsafe structure, pending removal review. It carried the HOA letterhead. Not county, HOA. I removed it carefully and placed it in a folder. That evening, I emailed Melissa. "Please provide the statutory basis for HOA authority over county drainage infrastructure located within a recorded easement." Her response arrived 15 minutes later. "The association maintains broad authority to protect community safety and standards. Failure to comply may result in enforcement action." No statute cited, just tone. A week later, I received a certified letter threatening fines if I did not remove or remediate the bridge within 14 days. I drove to the county public works office the next morning. They confirmed what I already knew. The bridge was installed as part of a drainage access project 5 years earlier. It allowed maintenance crews to reach both sides of the channel. It was county property. I asked if they'd received any complaint. They hadn't. That was the moment I understood something important. Melissa wasn't confused. She simply hadn't checked, and she was escalating based on assumption. I forwarded the county confirmation email to her. No reply. 3 days later, a contractor's magnetic sign appeared parked across the street. Demolition services. That was the first moment I realized she wasn't posturing anymore. She was preparing to act.
If you enjoy the video, please subscribe the channel and press the like button. The demolition truck arrived at 8:17 a.m. on a Thursday. I know the exact time because camera 2 captured it in 4K. 2 workers stepped out. One carried a clipboard, the other a reciprocating saw. Melissa arrived 8 minutes later in a white SUV. She wore sunglasses and confidence. I walked outside before they reached the fence. "Morning," I said evenly. She didn't greet me. "We're removing the non-compliant structure," she said. "The association has voted." "On county property? It's on your lot." I didn't argue. I asked one question instead. "Do you have written authorization from the property owner?" She lifted the clipboard. "The HOA has enforcement authority." That wasn't my question. She turned to the workers. "Proceed." I stepped back. That's important. I did not interfere. I did not block access. I did not raise my voice. I simply let the cameras record. They cut through the decking first. The sound of treated lumber splitting is sharp and hollow. The steel stringers required a grinder. Sparks fell into the creek bed. I documented everything. Close-ups, license plates, contractor logo, Melissa issuing instructions. At 9:42 a.m., the bridge was in pieces. By 10:15, it was loaded into a trailer. Before they left, I asked the contractor for his business card. He hesitated. Melissa nodded tightly. I thanked him. Then I made 3 calls. First, County Public Works. Second, County Risk Management. Third, my attorney. The county's response was immediate. By mid-afternoon, an inspector was on site reviewing the damage. He stood in the empty span where the bridge had been and asked, "Who authorized removal?" I replied, "The HOA president. I have video." I transferred the files before he left. The next development moved faster than Melissa expected. The county issued a formal notice of unauthorized destruction of public infrastructure. It wasn't addressed to me. It was addressed to the contractor and copied to the HOA. Replacement cost estimate? $38,600. Labor, materials, administrative penalty. The contractor called me that evening. "She told us it was private property," he said carefully. "It wasn't," I replied. The following Monday, the HOA sent me a violation notice for failure to maintain safe conditions following structure removal. I almost admired the audacity. My attorney responded with my behalf within the hour. The letter was precise. It included easement documentation, county ownership confirmation, video stills of Melissa directing demolition, and notice of potential civil claims for trespass and property interference. 2 days later, a sheriff's deputy delivered paperwork to Melissa's front door. Not criminal charges, yet. A demand for explanation. The county scheduled a public hearing regarding infrastructure damage and liability recovery. Melissa sent one final email to the neighborhood listserv. "Recent corrective action taken to address unsafe private structure is being misrepresented." That was the mistake, because by then the county had sent notices to the entire HOA board, and they were not pleased to discover they had just inherited a 5-figure liability. The hearing date was set, and it was public record.
The HOA meeting room was full. Not because of me, because of the assessment notice. The board had proposed a temporary special levy to address unexpected infrastructure expenses. Neighbors wanted details. Melissa opened the meeting with a prepared statement about protecting community standards. Then the county representative stood up. He introduced himself calmly. Public Works Division. He outlined the project history, the easement, the maintenance corridor, the bridge installation contract. Then he displayed the video. No commentary, just footage. Melissa instructing demolition. Melissa confirming HOA authority. Melissa nodding as steel was cut. You could hear the grinder in the room. The county attorney explained the legal framework: destruction of public infrastructure, trespass within an easement, misrepresentation to a licensed contractor. The recovery amount would not be assessed against homeowners. It would be pursued against responsible parties, individually. Silence followed. A board member asked, very carefully, "Was the association authorized to remove county property?" "No," the county attorney said. Another board member asked Melissa if she had verified ownership. She didn't answer directly. That was the moment authority left her. Not dramatically, just visibly. Within 30 minutes, a motion to suspend her presidency passed. The board voted to cooperate fully with the county investigation. The HOA insurer declined coverage due to unauthorized action. Over the next month, Melissa resigned. The contractor entered a settlement agreement and provided sworn statements. The county filed civil recovery action naming her personally. Restitution was ordered. Legal fees were assessed.
Her professional license, she worked in real estate, underwent review for misrepresentation. The replacement bridge was installed 6 weeks later. County crew, county equipment, proper permits. I watched from my yard as they set the new steel beams. One of the workers recognized me from the inspection. "Sorry for the inconvenience," he said. "It wasn't inconvenient," I replied. "It was instructive." The neighborhood changed after that. HOA meetings became procedural. Citations required documentation. Authority required verification. No one stopped by unannounced anymore. The greenbelt is quiet again. The bridge stands where it always did. Functional, unremarkable, properly owned. I didn't win by fighting. I won by letting the record speak. Because authority isn't claimed, it's proven. And when someone confuses position with power, the law has a way of correcting them.